the Uniform Civil Code.
The Uniform Civil Code.
What is the Uniform Civil Code? One nation, one law. एक देश, एक कानून. Is India ready for the Uniform Civil Code?
आजकल हम देख रहे हैं कि यूनिफॉर्म सिविल कोड के नाम पर ऐसे लोगों को भड़काने का काम हो रहा है। हमें याद रखना है कि भारत के संविधान में भी नागरिकों के समान अधिकार की बात कही गई है।
The draft of the proposed Uniform Civil Code is yet to be put in public domain. The Law Commission of India had been waiting for all submissions till the last day, which was the 13th of July. And the Commission is estimated to have received over 50 lakh suggestions, over which the Commission will now have the broader discussions. As we all have a general idea that the UCC, which is a directive principle under the Indian Constitution, is meant to be a set of personal laws that would apply to all citizens equally without any discrimination or any kind of partiality. The practices it includes are uniformity in law of marriages, divorces, succession, adoption, guardianship, and especially to do away with the practices that discriminate women. And no, the laws are not certainly going to interfere with what you eat, what you choose to wear, the religion you practice, or the rituals and customs of the faith you follow. So in order to have that one kind of universal law, the Law Commission will have to not only deal with the diverse religions, but also the backward and scheduled tribes as well. Apart from the Muslims who have strongly opposed the UCC from its very outset, the government will also have to deal with the whole range of issues with the tribal communities throughout India. So if or not the current government succeeds in intellectually as well as politically dealing with those issues and also in implementing the controversial law is something only time will tell. Introducing the UCC has been a long-standing agenda of the BJP, with the UCC finding its first mention in the party's election manifesto as far back as in 1996. And since then, direct reference to the Uniform Civil Code has been made in all its successive election manifestos as well. A remark by Prime Minister Modi while addressing BJP workers has sparked off speculations over the contentious issue, with some even speculating the UCC bill could come up in the parliament as early as monsoon session beginning July 20. As always, the battle is on, with the opposition calling the bill a mere political rhetoric, while others have been accusing the ruling party of polarizing voters ahead of the 2024 elections. But is the case really as it is made out to be? Let's find it out. When the issue of UCC was first raised in the Constituent Assembly on November 23, 1948 to be precise, and since then the UCC has every now and then figured in political debates and electoral politics, regardless of the government at the center. So the opposition parties calling the bill as a vehicle for Hindu majoritarianism is baseless and entirely out of place. Even Dr. Babasaheb Ambedkar, the architect of our constitution and the first law minister of independent India, was a huge supporter of the UCC himself, and he strongly believed that the UCC will not only reform the Hindu society but also benefit the Muslim women who had almost no protection under the Sharia law. The first Prime Minister Jawaharlal Nehru was keen to bring about a social reform, and so he called upon the first law minister Dr. Babasaheb Ambedkar to begin reforming the civil codes, but only for Hindus, Buddhists and Sikhs. Why? Because he did not want Muslims to be under the impression that the majority was imposing its will on the minorities. J.B. Kriplani, who had been the Congress chief in 1947, during a heated debate in the parliament, accused the then Congress government of being communal, as it was pursuing the Hindu Code Bill, which was not just a codification but abrogation and revocation of many Hindu practices and traditions. Whereas the Muslims continued to be governed by the Muslim personal law, which is almost entirely managed by Muslim religious heads. There were widespread opposition from the Hindus, as no one from the then ruling government wanted to take into considerations the opinions of the masses or even hold debates or discussions. Dr. Rajendra Prasad, the then President of India, was furious and argued that decisions regarding such an enactment of law should not be taken unilaterally and arbitrarily without the consultations of the parties concerned. He is even said to have refused to sign the law, leading to a major altercation with Prime Minister. But nevertheless, Nehru still went ahead in a dictatorial manner, claiming that the Muslims were not yet ready for reforms. More than 7 decades later, they still aren't. Anyways, Nehru went ahead with doing away with the Hindu personal laws and enacting the Hindu code bills one after the other, which were not based on Hindu Shastras but on Western principles, like the Hindu Marriage Act in 1955, the Hindu Succession Act in 1956, the Hindu Minority and Guardianship Act in 1956 as well, and the Hindu Adoptions and Maintenance Act also in 1956. 75 years hence, there is little doubt that India does need a uniform civil code for ensuring equality among its citizens. In a democracy like India, which is governed by rule of law, it is imperative that we continue to bring about gradual and progressive changes, making amendments to law that need to be readdressed and modified. Our constitution, as we all know, came into effect in 1950, wherein the Article 44 mandates a uniform civil code. Article 44 states, the state shall endeavour to secure the citizens' uniform civil code throughout the territory of India. The Supreme Court of India has time and again persuaded various governments to bring in the UCC, also referring to Goa's UCC as a shining example due to its features like compulsory marriage registration, prohibition of polygamy and bigamy, consent of both the partners in marriage and in separation, and so on and so forth. But we need to always remember that enforcement of ideology of equality is easier said than done, especially in a country as diverse as India. So you may ask, what exactly is at stake? Well, to begin with, as I mentioned earlier, apart from religious diversity, the Indian population is also distinguished on the basis of language, domicility, various traditions, and endless numbers of rituals and customs. And therefore, abandoning long practice and generations old customs is a humongously difficult task. For example, the Muslim community has two different schools, the Shias and the Sunnis, both of whom differ not only in their sects and the religious duties they follow, but in their organization and jurisprudence as well. According to the Sunnis, divorce can be oral and in written form, but for Shias, talaq or divorce in a writing is invalid. Sunnis do not require the presence of eyewitnesses during a divorce, whereas the Shias require at least 2 male witnesses. Whereas in the Vedas or any other dharmic text of Hindus, there is no context of divorce mentioned whatsoever. The Hindu marriage is considered sacred and hence unbreakable. While Muslim men are permitted to have as many as 4 wives, Hindu men can marry only one. While Hindu women can inherit an equal share of property as their male siblings, Muslim women inherit only half of their brothers. It remains to be seen as how the various methods of marriage and dissolution of marriage of the Muslim community will be dealt with. According to the Personal Laws of Parsis, which is Parsi Marriage and Divorce Act formulated in 1936, even before India attained independence, Parsi daughters who marry non-Parsi men lose their rights over parental property, whereas non-Parsi wives of Parsi husbands were entitled to only half of their husband's property. Similarly, Christian personal law differs that of Muslim or Hindus in many areas. While adultery is a ground for divorce for Hindus, Christians and Parsis, it is not so for Muslims. Impotence is a ground for divorce for Hinduism and Muslims, but not for Christians and Parsis. Again, the issue of underage marriage is ground for divorce for Hindus, but not for Christians, Parsis and Muslims. As you can see, these inconsistencies create endless chaos and confusion. To understand it better, let us take a look at some of the very unique cases that gain national prominence due to its complexities. The first case of Sarla Mudgal versus Union of India, where Sarla Mudgal, the chairman of a legal entity called Kalyani, specializing in the welfare of discriminated women. Sarla Mudgal was the first petitioner who filed a petition in the Supreme Court against Jitendra Mathur. Petitioner number 2, Meena Mathur, had 3 children with Jitendra Mathur, who married Sunita Narula after converting to Islam to avoid section 494 of the IPC, which banned Hindus from second marriages. Sunita Narula also converted to Islam and took on the name Fatima to legalize the marriage. However, in 1988, after Meena Mathur filed a case against Jitendra Mathur, he returned to Hinduism and promised to support his wife and 3 children from his first marriage. However, he refused to support Sunita aka Fatima and their illegitimate child because Fatima was a Muslim and was not protected by any of the personal laws. There was yet another case in 1997 when Christian pastor John Bellam filed a writ petition stating that the Section 118 of the Indian Succession Act discriminated against Christians. Section 118 of the Indian Succession Act imposes restrictions on Christians from donating their personal property for religious or charitable purposes through a will, in case if a Christian has a niece or a nephew or any other close relation in existence. After much debate, the Supreme Court held that the said act being violative of Article 14 of the Indian Constitution will be struck down as unconstitutional. In another case which belongs to the Santhal community, Bitya Murmu, who was just a child when her father passed away, according to the Santhal customary laws which does not give ancestral property rights to women, had a piece of land snatched away from her and her widowed mother, leaving them to the mercy of others despite being owners of a plot of a land. Such irregularities only strengthen the argument that discrepancies in personal laws should be erased once and forever and make way for gender justice and equality for all our citizens as assured in Article 14 and 15 of the Constitution. The reason why we have conflicting realities with regards to law and justice are because of sheer incompetence, shallowness and cowardice of some of the most prominent leaders who have been praised to skies throughout the history. What was lacking was sheer political will and the courage to take up an issue as contentious as the Uniform Civil Code. There was also a deep ingrained fear, or you may say compassion, for a particular community which is like termites, eating away India's foundation from its very roots. Anyways, getting back to the point, more than 220 ethnic groups, the country's northeast is considered to be one of the most culturally diverse regions in the entire world. According to 2011 census, in Mizoram, Nagaland and Meghalaya, the population of tribals is as high as 94.4%, 86.5% and 86.1%. Now this makes it crucial to evaluate how millions of indigenous people will react if the UCC gets passed. Above all, the protection of customary laws of such ethnic groups is currently guaranteed by the Constitution. Article 371G of the Constitution specifies that no act of parliament which impacts the religious or social practices of the Mizo ethnic group applies to Mizoram unless agreed by the state. Similarly, the Naga Tribunal Council has also put forth its reluctance, claiming that the UCC interferes with the Naga customary laws, as the UCC is expected to adhere to the existing polygamous and polyandrous practices still prevalent among several tribal communities throughout the entire nation, including the Naga community. The practice of polyandry and polygamy may sound like an extreme practice, but it is still in prevalence in many remote Indian communities. Polygamy is still in practice among the Naga, Baga, Lushai and the Gond tribes, while polyandry still finds prevalence through the Himalayan belt from Kashmir to Assam in the tribes like the Toda, the Gond and the Khasi. The Santhal community does not permit its women to inherit their father's property unless she marries a man and makes him a ghar jamai. In such cases too, she is to share the property with her husband. The Adyar community of Wayanad, Kerala considers elopement of a married person as a valid form of divorce. Not only that, the remarriage of such a person to a new spouse is considered acceptable. As we can see, taking the entire population of India on board in regard of the UCC in one single attempt seems a little far-fetched as of now. Although most personal laws are clearly discriminatory against women, the moot question here is, should the provision to protect the ethnicity of the tribals or any other indigenous communities be allowed to overshadow the purpose of the UCC, which attempts to establish equality between men and women throughout the entire length and breadth of the country? The Indian Constitution stands for equality and equal treatment before law, irrespective of religion, race, or gender. The implementation of the UCC could be an ideal and absolute goal for a country like India. But as always, there are still hurdles which cannot be overlooked. The opposition has warned the government of major social unrest and resentment in retaliation if the UCC is enforced. BJP's Rajya Sabha MP Sushil Kumar Modi, who serves as the chairman of the Parliamentary Standing Committee on Law, has suggested keeping the tribals, including those in the northeastern states, out of the purview of any likely uniform civil code. But how will various religious communities react to the exclusion of the tribals and other indigenous communities from the ambit of the UCC? Or will the enforcement of the UCC without any predisposition spark communal tensions? Whatever the ruling party settles on, what I am sure we will all agree on is that the government is walking on a tight rope. And at the end, we have a request for all our viewers. If you like our content, please like and comment on our video, because it doesn't just increase our reach to more viewers, but also it encourages us to bring more such videos. So don't forget to like, comment and share our video, and please don't forget to hit that subscribe button for more such upcoming videos. Thank you for watching.